best place to start any story is usually at the beginning. So that's what we're going to do. We're going to go back to December 30th, 2022, when Ann Taylor was first appointed to represent Bryan Kohberger. We're going to look at how and why that happened. December 30th, 2022 is the first day that the world learned of Bryan Kohberger. It's the day that he was arrested in Monroe County, Pennsylvania, and held for extradition proceedings to send him back to face these murder charges in Latah County, Idaho. That same day, Magistrate Judge Megan Marshall signed an order appointing Ann Taylor as Bryan Kohberger's public defender. Ann Taylor also filed a notice of limited representation where she indicated she was undertaking the case pending agreements being reached between herself, the Kootenai County Public Defender's Office, for whom she works, and the Latah County Public Defender, for whom she is being asked to take on this representation. So obviously, Ann Taylor doesn't work for Latah County. So how did she end up in this position? Let's start there. So to understand the context in which this appointment took place, we have to backpedal just slightly to 2015, when the ACLU sued the state of Idaho in a class action lawsuit alleging that essentially their public defense system was constitutionally inadequate, that there were systemic problems that would persistently deprive defendants of their basic right to counsel. Now, while this case does remain ongoing, it's currently set for trial in 2024, after some initial back and forth in the litigation, the state of Idaho moved to address some of these concerns by creating a public defense commission and adopting certain standards for public defense contracts, public defender qualifications, caseloads, and things of that nature. We're going to turn to look at the requirements that these rules impose for capital defenders. The first thing we see from these rules is that a capital case doesn't actually mean that the death penalty is currently being sought. We know from the filings in Bryan Kohberger's case that the state has not yet filed a notice of intent to pursue the death penalty. And under Idaho state law, this is a prerequisite for a death penalty sentence to be imposed. But under this rule, if the state is legally entitled to file that notice, then the case is going to be treated as a capital case. So this, in my view, along with what frankly appears like a pretty strong likelihood that a capital sentence is going to be sought in this case if there isn't some plea negotiated resolution. This is why the capital standards are being applied in this situation, even though we're not technically at the point yet where a death penalty sentence could be imposed. The public defense standards impose requirements on courts when they are appointing public defenders in different types of cases. And so in a capital case, the court is required to appoint a defending attorney from the capital defending attorney roster to represent an indigent person at public expense. We're going to get back to the capital defending attorney roster. They're required to inquire about the defending attorney's workload to ensure compliance with the public defense rules. We're going to get back to those workload rules. At or before the initial appearance in a capital case, appoint no less than 2 qualified capital defending attorneys, 1 designated lead, and the other as co-counsel. The court shall not appoint a defending attorney to any case with a conflict of interest in that case. And finally, if you don't meet the eligibility requirements to be on the roster, you can't be appointed for those cases. There were some concerns that I saw initially about the timing of this appointment. The fact that Ann Taylor was put on the case before Bryan Kohberger was even back in Idaho, just barely getting to know who he is. And the Idaho court is already taking this action. Suggestion that perhaps there was maneuvering or, something improper going on with that. And so I hope this rule clarifies that before the initial appearance in the capital case, the appointment is appropriate. When you look at the timeline of how things unfolded here, it was the day before this, December the 29th, when prosecutors got the arrest warrant based on the probable cause affidavit that was filed. Got that, over to Pennsylvania and got him served and arrested, and the case has moved from there. So this all unfolded rather quickly. We can anticipate that as the court and the parties are becoming aware that this is about to land in court, they would begin to take steps to start to figure out, where are we going to go with this? Who are we going to be appointing? And that kind of thing. So the timing of this does not strike me as anything particularly alarming at all, particularly when there was this stuff going on in the background as well, with the state potentially trying to return the possession of the property and the contents of the property where this took place to the families of the victims. And there was an emergency, essentially short notice motion filed to preserve the crime scene for a short period of time for the defense to be able to do some investigation of that as well. So given all of these things kind of coalescing at the same time, this timing does not surprise me at all. It would be kind of more of a concern from my standpoint had they not done this and had, the crime scene then potentially been tainted by allowing, people who are not, crime scene technician type people to enter the property without taking the appropriate precautions and so forth. That would have potentially created a much, much larger problem than simply finding who we're going to appoint as the defense counsel in this case, getting them on board ASAP, and putting them in a position to be able to take action to protect the defendant's rights in that situation. So why did Latah County turn to Ann Taylor in this situation? Well, I think we can get that answer pretty easily by looking at the public defense roster for the state of Idaho for Capital Counsel. And what we see from that is there aren't an awful lot of them to choose from in the first place. There's 30 total attorneys on this list, but only 14 of them are qualified to be lead counsel in a capital case. We can also see that there is a bit of a geographic distribution problem with where these attorneys are. Latah County is in the 2nd Judicial District of Idaho. We don't have any qualified capital attorneys, either lead or co-counsel, in Latah County in the 2nd District. We do have some in the 1st District where Ann Taylor is, and we see she's the only lead qualified attorney. There are a couple of others who are qualified as co-counsel. The overwhelming majority of these lawyers are in the 4th District, which is where Boise, Idaho is. That's the big population center in the state of Idaho. So that makes sense. But the problem is that Boise is over 300 miles from Moscow. It's close to a 6-hour drive to get there. So this is not going to be your first choice of attorney to pull from, because it's going to be very, very difficult for a public defender to be able to manage that kind of travel requirement. You're going to either need to be making a very long drive very regularly all the time, or you're going to need to kind of relocate to be closer to where witnesses are and the court hearings are and things like that, certainly where Mr. Kohberger is. It's not really realistic to expect a very small county like Latah County to jump right at the idea of the expense it's going to entail to bring in somebody that distant to be lead county on the case. Their preference is going to be to get the closest person that they possibly can who's qualified to handle it. So the obvious person in that situation is Ann Taylor. Now, obviously, this is just the county's preference, and, money and Sixth Amendment rights do often kind of run into a little bit of tension Hence that 2015 lawsuit from the ACLU that we talked about before. Again, it's not a cause for alarm for me that they would choose to look at her as the best possible option available to them. Now, clearly, if there is some reason why she should not take the case, such as the rules tell us, if she's got an actual conflict of interest here, then she's not the right person, and the county is going to have to just suck it up and, bring in the expensive person, from Boise or wherever else. So that's going to be the opportunity now for us to turn to the question of the conflict of interest. Did Ann Taylor, on December 30th of 2022, when she took this appointment, have a conflict of interest that should have disqualified her? Well, let's look at that next.